Hi, it's Roland Jones. This is a short video, part of a series of videos on preference and fraudulent conveyance issues. This is a fairly recent case. The issue here is whether the defendant was able to overturn the insolvency presumption provided to the trustee by the bankruptcy code. In other words, did it have sufficient evidence to show that the debtor was solvent? The defendant was a property management service, received payments from the debtor, and was sued by the trustee for a preference after the bankruptcy filing. The defendant argued that the defendant was solvent, and it based its argument on an email it was able to obtain from the debtor to a lender. And in the email, the debtor stated that its assets were more than its liabilities. The defendant argued that this was good evidence that the debtor was solvent at the time of the transfer. The trustee argued that better evidence was a balance sheet from that time period that showed that the debtor was completely insolvent. And so the question was, well, what's the court going to consider? An email to a lender or a balance sheet that was maintained internally? Bankruptcy Code section that's applicable is 547B3. Drum roll. Well, not too surprisingly, I think the court put more stock in the internal balance sheet than it did an email to a lender. I think it's pretty obvious that the debtor might have had a good reason to communicate to a lender that it was solvent. I don't know if the communication was for additional loans, but at any rate, the court found that a balance sheet was more convincing evidence. The court also rejected other arguments, but I think the main takeaway here is that the case just shows a little bit of the kind of analysis the court is going to do in an attempt by the defendant to come up with some kind of evidence just to rebut the insolvency presumption, but it just wasn't enough. But it's illustrative of the kind of litigation that goes on with respect to solvency.